Good afternoon, dear colleagues who continue our working day. And I give the floor to Viktor Martovskyi, activist of the NGO Molot, Iryna Perkova, coordinator, Ukraine Crisis Media Center in Mariupol, via Skype. And we are going to speak about corruption court hearing in Mariupol. Good afternoon. Today we are going to tell you about the situation in Mariupol courts, not only in Mariupol but also in the oblast. But we are concerned with Mariupol. The situation is that they postpone the work on bringing to responsibility those who organized the referendum and those who took part in separatism. And this is sabotaged by some judges and prosecutors' office. They neglect their responsibilities, and the judges do not want to consider the petitions, and they don't want to accept evidence. And our detention facilities are filled with the patriots who are there, and those who were involved in separatism. Those people are not brought to justice, and judges who were involved in all this, they should be fired, and we do everything possible in order to do this. There are corruption components in the local government, prosecutor's office. They do not want to work. And there was a terrible example with a judge in Zhytomyr region. This judge released the one of the separatists.
The situation is as follows. I would like to be brief, but to give all details about this flagrant incident. In October last year, Nesteryanko Vladimir was detained. He is an owner of a publishing house based in Donetsk. It is rather large. Nesteryanko is its owner, but he is not only owner. He also was involved in operations. He controlled operations of the enterprise. So he controlled the activities during previous 2 years. Maybe you have some device close because the connection is bad. Now the connection is better. So I continue. Nesteryanko, along with his companion, organized the production of newspapers of DPR and all letter-headed documents of DPR. They are issued on this publishing house published papers, and he also visited the Russian Federation, Germany, Canada, and other countries to organize supplies to his publishing house for its operations. And his companion was in control of printing services directly. So he also helped DPR with the other publishing house in the area of DPR. He also supplied paper and other components to that printing house. So he was involved in publishing of these informational war tools to the leaders of DPR. And this is proved by the investigation. And the court admitted that the convictions are well grounded. He was detained in October last year, and on December 21st, the decision should have been used by the court, and the investigator submitted a petition on selection of pretrial restrictions method, and the judge didn't found any risk that this person can disappear. Nesterenko may disappear from under arrest and from access by the investigation. And the judge issued the opinion about the mild pretrial restriction. There are 5 pretrial restrictions. The remand in custody is the most severe one. Then also the person may stay at home, and he was stayed at home, and he should have visit the investigator's office by request, and that person had a passport of a citizen of Canada, and he could easily issue himself a passport because he was an owner of a printing house. As a result, Mr. Nesterenko fled, and the investigation doesn't know where this person is nowadays. The other important fact is that this enterprise named Novy Svet, New World, it supplied high fees to Viktor Yanukovych for his memoir books. This was indeed money laundering operations, and Mr. Nesterenko could have told us many interesting things about those money laundering operations and how the judge let him go. It was conducted by the judge violating the Article 3 of the Criminal Procedure Code, which meant that the suspects could only be under arrest. And the judge did not mention it in the motivation of his judgment. This was a vivid violation of the procedural code, and the judge issued a decision about the appeal process, and Article 176 banning to apply any pretrial restrictions, and the first instance court was decided to be right. The Court of Appeals covered the actions of the first instance court. On December 9th, 2014, the Supreme Specialized Court issued an explanatory note where it made all courts responsible for harmonization of pretrial restrictions measures. They are not subject to appeals. This was so adopted in 2014, but these two courts negotiated and agreed, and they had a conspiracy between themselves. They demonstrated as if there was no such elucidation, that a court of appeals is not allowed to consider pretrial restrictions. The other court can't try the restrictions. So we applied to court with a petition seeking to make the judge liable for deliberately illegal judgment of the court issued by a judge. So we applied to the court, we filed the petition to the first instance court where Kurchenko works. Our petition was transferred to the other court of Mariupol, Primorsky district court. So the court issued a decision that she has no right to try Judges Kurchenko's actions, but this is not true, because there is Article 9 of Criminal Procedure Code saying that the investigator should issue an opinion. We blame the judge, but there is another rule of law by the plenary session of the Supreme Court of Ukraine of 2008. This resolution is saying that nobody can judge the judge's actions. So we have a collision, a conflict of interest. On the one hand, the investigator should give the assessment, and on the other hand, the plenary session's resolution says that the other judge can't assess actions of some judge. So we have the vicious circle due to these controversial rules of the law of Ukraine. So again, we went to the prosecutor, to the regional prosecutor, and he promised to send our petition to the higher instances. This was a deliberately illegal decision of the judge. Well, they will try to prove that he didn't know, so it was not a deliberate illegal action. It was illegal action, but not deliberate, they say. If this is a tram drive and he will cause trauma, he will be punished rather seriously, and the judge remains not responsible, not liable according to the law. Also, he is a well-trained person, so this impunity causes lack of responsibility among judges. I think that Nesterenko gave the investigators and the judges bribes because he is a wealthy man. I am sure there were bribes. I think the situation, fortunately, is similar all over Ukraine, but we are the country at war, and persons who are blamed of separatism. They are judged by our judges. So we are not inclined to stop. The judges' community is rather closed one, but in Turchenko-Nesterenko case, we should search for a precedent. We should create a precedent, and we have a favorable time for this. Turchenko judge has his powers been at the end, and now the question of continuing his powers is now on the agenda. So we have filed the petitions with the Parliament and with the Higher Qualifications Commission, and our letters are signed by NGOs and individuals. And this letter, we have already discussed it with the Higher Qualifications Commission of Judges of Ukraine, and it would be taken into considerations while considering the matter of awarding continuation of powers to the Judge Turchenko. So we will also submit the letters, and we will continue our fight. Because in Mariupol, our pretrial detention centers are full of patriots, and at the same time, those people who are separatists, they are released, they are let go. So Novorossiya, DPR, LPR newspapers, they are aggressive, they are of propaganda, and they are doing not less serious things than the people who shoot. So these oppositional members, they should be punished, and the precedents should be created, and the judges should be dismissed. I would like to add, but please check whether you have telephones close to you. I would like to tell one thing: when the law is silent, then disorder starts to act. So the case has not been put on the register by the justice system, and now the civil society took the initiative because they saw that prosecutor's office is inactive. We should take actions because people, as all of us know, accumulate weaponry. That is why we need to punish offenders by the law, but not waiting for civil society to take illegal actions.
Питань.
Are there any questions? There are no questions from our colleagues, so thank you very much for focusing attention on this topic. Thank you very much.